Now I want to talk to you about the 9 great myths about DUI cases. Myth number 1, I have to answer questions when the officer asks me. No, you don't. You're only required to provide necessary documents like license, registration, insurance, plus your name and your current address. If that's on your license, say it's on my license. If asked more questions, politely decline to answer. If pressed further, say, I don't see what this has to do with whether I committed a traffic violation, and remain silent at that point. The roadside tests that I've seen officers give to DUI suspects on television programs are mandatory, and I will lose my driver's license if I do not attempt these field sobriety tests. That's incorrect. Even though the officer will make it sound like these tests are mandatory, none of these tests are required. None of these tests, if you don't do them, will cost you to lose your driving privileges. Roadside exercises, an officer will tell you, are there to make sure you're safe to drive. These are optional, voluntary, and are graded on such a difficult standard that you couldn't pass them on your best day, much less on the side of the road under adverse circumstances. Always say no to roadside tests. Myth number 3, I can't be arrested unless I'm drunk. That is not true in any state in America. Laws have been written broadly to allow conviction of anyone who has been affected by alcohol or any other impairing substance to the degree that your mental or physical faculties, or both, are not as sharp as when you had no alcohol or other impairing substances in your system. Myth number 4, I must be driving before I can be arrested for DUI. Not true. In virtually every jurisdiction in the United States, you can and will be arrested if you're inside a motor vehicle, even a parked motor vehicle, even with the engine off and the key not in the ignition switch, if you have actual physical control of that vehicle. By law, that means, do you have the key, and does that key crank that vehicle? So you can and will be arrested for DUI in those circumstances, even if you're asleep in the car. This can even happen in most states when you're on private property, such as a restaurant parking lot, or even in your own driveway if you're asleep behind the wheel and you've got the key in the car. Myth number 5, if the officer arrests me for DUI, I simply will not take the breath test, and that will prevent me from being charged with a DUI. Absolutely false. In every state, officers who gather sufficient evidence of your impairment from any type of substance can make an arrest for impaired driving. In addition, officers in most states are authorized to forcibly draw your blood or obtain urine by way of a catheter if you refuse the official test. In about 20 states, a court order is needed to do this, but in many states, your mere refusal provides a legal basis to collect this important evidence. If you resist this effort, you will also be charged with obstruction of a police officer or possibly felony assault on a police officer. Myth number 6, if stopped and suspected of DUI, I will just tell the officer that I'm not doing or saying anything until I speak to my lawyer, and that announcement will protect me from being charged with a DUI. No, it will not, and no police officer in America will let you take off the cuffs and call your attorney from the back seat of a patrol car before he or she finishes processing you into jail. In the few states, such as North Carolina, that do permit a DUI suspect to make a call to legal counsel before deciding whether to submit to the official test under the implied consent law, or sometimes called the informed consent law in that state, whether you do call or not will not prevent you from being accused of DUI. In addition, your refusal to say yes to the official test after being arrested can cause total loss of all driving privileges for up to 1 year or more. Myth number 7, by putting something in my mouth, such as a penny or a peppermint or gum, or possibly swigging some mouthwash that contains alcohol, I can throw off the officer's suspicion that I'm impaired by alcohol. No, it will not deter the officer from arresting you, but this fact will be part of the officer's report saying that this tactic is routinely used by drunk drivers to try to fool a police officer. All of the same guidelines as stated above: be polite, be silent, and only give your name and current address, are what you should do, and not try to get an attorney before the officer finishes his or her investigation. Myth number 8. If I am stopped and the officer smells alcohol or drugs, I can talk my way out of being arrested. Not today, that won't work. Any begging, name-dropping, or attempts to use your fame and stardom will be captured on video and will be argued to a judge or jury as being a pathetic attempt of this dangerous driver to be given special treatment and not held accountable for his or her drunken driving. Be silent and submissive to the officer's commands, like put your hands behind your back, but still not doing or attempting to do the things I've outlined for you in this video. This probably gives you your best chance for a dismissal, a reduction, or an acquittal if it has to go to trial. In the event that the officer arrests you with no substantial evidence of DUI, then this arrest should result in a court dismissal or a reduction. Whatever circumstances led you to be driving while you have the smell of alcohol or drugs, so that you have then been targeted as a DUI suspect, your name dropping, your talking, your begging to let you go will not do any good. Myth number 9. A misdemeanor DUI charge is no big deal. Nothing could be further from the truth. In most jurisdictions, a DUI conviction remains on your record for life. You take it to the grave. As you're going to learn later in this video, if a person is seriously injured or killed by you driving impaired, you can face felony charges that range from 1 year in prison up to life imprisonment. Different states classify the unintentional causing of a death by virtue of being DUI as a serious felony and call this offense either homicide by vehicle, vehicular manslaughter, or even murder in several states, including Alabama and North Carolina.